Suppose it is not permanent, then what is the manner of abrogating articles? Is that procedure followed or not?
That's correct.
The only two issues as I see in the whole
I'll hope and try and convince you that it is permanent. I will try and convince you. I know, your Lordship says it's debatable, and it is debatable. There's no doubt about it.
So both things are debatable means both sides will argue this point out.
It's really debatable. But I tell your Lordship, why it is permanent. Now, for the moment, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether the procedure has been followed or not followed. They will say we followed the manner of abrogation.
Absolutely.
You will say not.
Now, so far I've only referred to provisions of this Constitution. But your Lordships will have to look at the Constitution of Jammu and Kashmir. Because that Constitution, was framed and cleared in 1957. Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your Lordship, it can't do anything more than that. Right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent. So nothing is excluded. There's no specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why the 54 order says what it says. Provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only, the word which seems to indicate that these are the parts, the provisions which will apply. But Mr. Sibal, you are right that the constitutional practice which was followed since the adaptation orders proceeds on the basis that government selectively applied provisions of the Constitution to Jammu and Kashmir. They never treated it as if all provisions apply. The really clause D is susceptible of two interpretations, but the constitutional practice supports what you are arguing. We'll of course have to hear the learned AG on that.
Now, we move on to what happened in 1957 when the Constituent Assembly drafted this Constitution and was adopted. And remember, the 1954 order came when the Constituent Assembly was there. They had a choice. They could have said, no, we want...
57, what happens at 57? Let's see then.
But I'm just saying the Constituent Assembly was constituted in 1951, I think on the 10th of May, if I remember correctly. And then 54 order was passed. They could have said, look, no, we'll abrogate 370 and be part of India without conditions and be like any other state. They chose not to. And you will see that in the Constitution itself. I'll show it's better we look at the Constitution.
There is no dispute about the proposition. 370 remained in the Constitution. So nobody is arguing that 370 was not there. Otherwise, where was the occasion to abrogate it? Only issue is whether it requires a permanent character, which cannot be touched, or whether there is a methodology, right or wrong, there is a methodology by which 370 can be abrogated.
Correct.
That's the first part of your argument, as I understand.
Correct.
And in the alternative argument is, even if you don't accept my first part of the argument,
the methodology was
wrong.
No, sir, I'm sorry to interrupt, but on this permanent statement, 370 is in three parts. The first part, our argument is, continues, always. Second part is transitory, because it's dealing with what happens before the Constituent Assembly comes in and Constituent Assembly has to ratify. The third part is temporary, while the Constituent Assembly is there. Just putting it in a nutshell, that's our argument.
Yes, you are saying, according to you, 370 is structured in a manner whereby some part will go away or become otiose, and some part becomes otiose because in 1957, some other part becomes otiose later on. So you say one has a permanent feature. That is our argument.
The Constituent Assembly effectively had a choice to exercise 3 or to allow 1
till 1957. Your argument is all these choices were available only till 1957.
Yes, that's
that is your argument.
No, let's not debate it.
In fact, that's why the explanation to B contains an exhaustive definition of what is meant by the government of the state. Government of the state does not say includes the Maharaja. It says government of the state means the person for the time being recognized by the president as the Maharaja of Jammu and Kashmir, acting on advice of the Council of Ministers for the time being. Now, what happens when the Maharaja is replaced by an elected government in Jammu and Kashmir?
Then the elected government on the aid and advice of the Council of Ministers.
Where do we get that? Because the explanation says government of the state means.
Well, I'll show that to your Lordship. That's also there. It is part of the Constitution. I'll show that.
This explanation was introduced in 1952.
Well, there is a government order of 1965 which says that Sadr-e Riyasat will be in the governor.
50, 67?
Yes, 1965 order.
65. So till 65, did the Maharaja continue to...
Yes, yes, Malad. Then
There were separate powers of Sadr-e Riyasat.
Yeah.
The
But Malad, ultimately,
equivalent of chief minister was called the prime minister.
yeah,
For
that's
a long
correct.
period of time.
But
And
in
those
65, Malad, it was the
ceremonies were,
governor. There's an order to that effect. So be that as it may, Malad, I think we're traveling a bit too far at the moment. The governor may from time to time prorogue the houses or either house or dissolve the legislative assembly. This he can only do it on the aid and advice of the Council of Ministers. It's not an exception because the exceptions are 36, 38 and 92. This is important because it really, the issue will arise because Malad, there was no Council of Ministers when he did this, which is on the 21st of November, 2018. Malad, the importance of this is that he can only dissolve the Legislative Assembly on the aid and advice of the Council of Ministers. The only exceptions that the governor has in the terms of his exercise of power are 36, 38 and 92, which he need not do on the aid and advice. But under 53, he can't do it without the aid and advice, which is what he did. So I was mentioning, Malad, as far as 53 is concerned, that power to dissolve the assembly would only be exercised on the aid and advice of the Council of Ministers. So when he dissolved the assembly on the 21st of November 2018, he didn't do it on the aid and advice. And this governor's power has to be exercised in that fashion. The only exceptions are 36, 38 and 92. But this he can exercise without the Council of Ministers, unlike in the Constitution of India. Why? Because Jammu and Kashmir has a unique status in the context of its relationship to the government of India. So, the proclamation was issued on November 21st, 2018, on 20th of June. It was to expire in 6 months' time, on 19th December. And he, on November 21st, he dissolved the assembly, and without reference to the Council of Ministers. Now, this is important, provided further that no bill or amendment seeking to make any change in this section or the provisions of sections 3 and 5 or the provisions of the Constitution of India as applicable in relation to the state shall be introduced or moved in either house of the legislature. So, Maharaj, you cannot amend 370 as it is made applicable to the constitutional order made applicable to the state of Jammu and Kashmir. So no legislature can even move a bill. This is what makes it permanent. This is exactly why it is permanent. It had to be temporary because at that time there was no constituent assembly. It was temporary, it had to be temporary. Per force it was temporary. Even 3 cannot be amended. Section 3 cannot be amended.
But can the permanency of Article 370 be a consequence which follows from the Constitution of Jammu and Kashmir?
No, it's made applicable to Jammu and Kashmir by an application order.
No, but you're saying that this provision,
Yes.
Article 147 of the J&K Constitution,
Yes.
makes Article 370 permanent. Can the permanency of the Indian Constitution...
Yes, because, kindly see, the 370 was made applicable to the state of Jammu and Kashmir by an application order. 373, kindly, subclause 3 gives powers to the Constituent Assembly, no?
Those powers clearly
doesn't have. That legislature doesn't have those powers. Country middle what happens is when you impose Article 356, you took over the powers of the legislature. Under which power did they exercise that right?
Not of the legislative assembly.
Yes, exactly. That's what I'm saying, Malad.
Mr. Sibal,
But then how is proviso C will applicable?
Yeah.
How can you are saying Article 147 gives the permanency to Article 370?
Because the Constituent Assembly, I'm sorry, I shouldn't interrupt your lordship.
Now, can the Constitution of J&K give a permanency to Article 370 of the Constitution of India?
But that's all we are saying is that the Legislative Assembly does not have the power under 370 subclause 3. That's all that I'm saying, nothing more than that.
What you are saying is Legislative Assembly cannot exercise the power under the proviso to clause clause 3
Yes.
of Article
So what,
370.
then what, that's what, why they did, they converted the Legislative Assembly into the Constituent Assembly. That's what they did, Malaj. This is what is shocking.
The lighter side, the parliament did it.
I'm sorry?
On the lighter side, the parliament did it.
Yes. So Parliament converted itself into the Constituent Assembly of the state. I mean, it's unheard of. Yes, no means, but we'll show it. We'll show it. We'll demonstrate that. At the moment, all I'm saying is, Malas, you cannot exercise, the legislature cannot exercise powers to amend 373. Yes, even some other body takes over those powers, that only powers can be exercised is the powers of the legislature, nothing more than that. That's the whole scheme of 356 is if you take over.
Parliament can do it or not.
Yeah, well, Parliament exercises the powers of the legislature under 356. It can't exercise any other power. And that's the scheme of 356, which I'll come to later. That's Bomai, mothers, now that's settled. You can't arrogate to yourself a power that the legislature doesn't have. That's why there's an interplay between the Constitution of India, the Constitution orders applicable to the state of Jammu and Kashmir, and the Constitution of Jammu and Kashmir and 370 itself.
That's what you flagged in the beginning when you began your speech.
That's the issue.
Actually, Article 147, the second proviso to Section 147 of the J&K Constitution, would seem to indicate that the provisions of the J&K Constitution are treated to be subordinate to the Indian Constitution. Which is why no amendment in the relationship of the Indian Constitution and its application to the state can be introduced in the state legislature. The state legislature cannot change that relationship.
Correct, but I'm not disputing that. It is the legislature cannot introduce a bill to that effect. And what's the procedure? Only under 370. It's only under 370. Man.
But this is in that sense a subordinate instrument in its application to the relationship to the Constitution of India.
But let's kindly see, one second, kindly see, just 1 minute. Kindly see the Constituent Assembly has now framed the Constitution. The Constituent Assembly has not exercised the power that it had, Malaz, to abrogate 370. In that process, the Constituent Assembly, when drafting the Constitution, decided that nobody can change that status. The legislature cannot change that status. Now, whether Parliament on its own can change that status is a separate issue. But the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put it that way.
The legislature has no authority to change the relationship between...
That's correct.
Legislature
can change. Why? Because this is not a temporary provision. That's clear, Manoj.